Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on protective assessment. Generally, protective assessments are done in those cases where the department is not sure that where the actual assessment of that money is to be made. But the question before the Amritsar I.T.A in the present case was that if the assessing officer has made the addition of some amount in the hands of some person after duly inquiry done by the assessing officer, then whether in that case also he can done the addition for the same amount in the hands of the other assessee on protective basis. This issue has been taken up by the Amritsar I.T.A in the case of Mandeep Singh versus Income Tax Officer, and this case is reported in 126 I.T.A Tribunal at page number 240. The date of the judgment is 30th June 2025. The facts of the case are like this. The present case relates to the assessment year 12-13, and in the present case the assessee is a retail trader of foreign liquor under a license granted by the state excise authorities. During the assessment year 12-13, for that year, a notice under section 148 was issued to the assessee on the basis that information has been received that a cash of rupees 15 crore has been deposited in a bank account related to his trade name, and that cash has been deposited of an amount of rupees 15 crore between 13th March 2012 to 26th March 2012, that is within a period of 14 days. During the assessment proceedings, the assessee pleaded that this is not my account, this account has been opened fraudulently by two persons, and the assessee denied all the transactions. The assessee also filed the FIR for this account which has been wrongly opened by some persons, fraudulently opened by some persons, and he also made complaints to other agencies also. When the assessment proceedings were going on, the assessing officer made proper inquiry, and after doing the inquiry, the assessing officer came to know that the cash which has been deposited into the account of the assessee has been transferred to some other person's account, and the assessing officer accordingly made the addition under section 69A in the PAN number of those persons, meaning thereby that the substantive additions were done in the hands of those persons who deposited the cash and transferred the amount in their accounts. But at the same time, as a precautionary measure, the learned assessing officer also made an addition of the same amount on protective basis in the hands of the assessee, which the assessee challenged before the CIT appeal, and the CIT appeal also denied the appeal of the assessee. When the matter was before the tribunal said that in the present case the pertinent fact is that the assessee has claimed only the TCS for the purchases made by him in his regular account, and he has not even claimed the TCS for the purchases made in an account which has not been opened by him and which has been opened by some fraudulent persons. The tribunal said that in the present case it is not humanly possible for the assessee, who has got a very limited license from the state authorities to sell the liquor, that he can make a sale of rupees 15 crore in a span of 14 days. And the tribunal also said that in the present case the assessee has also filed the FIR and has made complaints at the various forums, and the law will take the action in the due course. And when the assessing officer was very sure that the assessment and the addition is to be made in some other persons under section 69A, then at the same time when the FIR has been lodged by the assessee, the addition on the protective basis in the hands of the assessee is not justified, and hence accordingly deleted the addition. At the end of this video, once again I am repeating the name of the case. The name of the case is Mandeep Singh versus Income Tax Officer, and this case is reported in 126 I.T.A Tribunal at page number 240, and the date of the judgment is 30th June 2025. Thank you, friends.